We are back. We're prepared to address our 115 landlord-tenant matter and expect a ruling here in a bit.
What you're about to witness is not just a routine landlord-tenant dispute. It's a full-blown legal tug-of-war over one critical question. Was this a lease or a land contract? That distinction changes everything. One side believes they're tenants facing eviction. The other claims they're buyers with redemption rights. And the judge? He's about to dig deep into case law, contracts, and decades of legal precedent to decide who's right and who's about to lose their home. Stay with us, because this ruling carries serious consequences.
We did not go live again after the completion of the last case. We were unable to resolve the last matter, Edgewater versus Sanders. The parties worked on it from 11 o'clock till 1:15, and we did not reach a resolution. So that matter is going to be set for further hearing. It was one of those no lunch days, but we're here and we're actually pretty much on time. What we're going to address now is the matter of John and Lorraine Williams versus Mark David Hart and Johanna Green. Mr. Matt Davidson is here live in the courtroom with his clients, John and Lorraine Williams. Present by Zoom is attorney Alea Patel and Mr. Hart and Ms. Green. I gave the parties the options of coming here live today or appearing by Zoom, and so the Zoom appearance is fine with the court. So is the live appearance. This matter was filed as a termination of tenancy of a lease by attorney Davidson. The defendants, the tenants, retained counsel, and she's here on their behalf. Their contention was this was not a lease, but it was a land contract. The plaintiff's contention was it was a lease, and they wished to terminate the lease and give the defendants 10 days to move out. The defendant's contention was that it was a land contract, and as such, they would have the right to redeem the land contract either within 90 or within 180 days and reclaim the property. So we had a couple of sessions on the matter and were unable to resolve that question. In hindsight, maybe it was resolvable, but I don't know. So each party has briefed the matter. Mr. Davidson filed a fine brief indicating it's not a land contract. Counsel has filed a brief that says in certain circumstances, you have the opportunity to rely on parole evidence. That's evidence extraneous from the document itself to determine what the meaning was in entering into the contract. And I enjoyed each of your briefs, and I've spent quite a bit of time reviewing this. I've read the cases that were cited by counsel. I've read cases that I found in my own research. I've looked at the previous agreement, and I've looked at this agreement. And I indicated by the email I don't need any additional testimony. I think what we've got is a sufficient record to make a ruling, but I allow anybody to make any final argument regarding their position. Mr. Davidson has indicated, I enjoyed your brief. Anything else you wish to say regarding what you pled in the brief?
The plaintiffs don't agree with all of the factual, we're treating this like an issue of law.
It is.
So that if there were allegations made by us, allegations made by them, that would be subject to evidentiary evidence being put in. So as long as it's clear that we're not conceding the factual allegations made by the defendant, then we have nothing further. We'll rely on the arguments, unless you have questions for us.
I don't think so. Ms. Patel, your brief was very good as well. Anything else you'd like to argue?
No, Your Honor. I believe that our brief was very thorough about the law. There are just a couple of things about the plaintiff's brief, just in terms of facts, I'd like to address that I will keep very, very brief, because I know you had a lack of lunch. So first off, they claim that the agreement for the alleged option to purchase was motivated by payment issues in 2022. We were confused by this in the timeline, considering the agreement in question was executed in 2021. Second, they reference this familial generosity that is irrelevant and untrue. My client states that they are not close in any traditional familial sense that would warrant or motivate them to treat my client any differently in terms of generosity. And then finally, that the plaintiff's brief refers to these text messages between the parties where my client uses the word rent as an alleged admission that it was a lease. I spoke to my client. It was one of those things where it was just easier to use the word rent, but in no way was meant as an admission on the lease. That said, we're just asking the court to construe this agreement as a land contract because it's the most equitable solution for the parties. Thank you, Your Honor.
Thank you.
I had nothing further, Your Honor.
All right, thank you. It seems like this question would be simpler than it was. If you could just go to the case law or the statute or the court rule and look up what's the definition of a land contract. And I looked all over the place. I looked at cases that were cited by cases. I looked at the court rule. I looked at the statute of frauds. I looked at the land contract statute at 565-361. I read the interesting case of Zurcher versus Hervate, 1999. The docket number, I don't have the citations in the brief, but it's 206948. Speaks to this. The case quotes, "We may start with this one general doctrine. There are few, if any, specific and uniform requirements. The statute itself prescribes none, and a study of the existing thousands of cases does not justify us in asserting their existence." So there isn't a case that says these are the elements of a land contract. Now, there are things that are generally in the land contract, but
This is where the case becomes legally fascinating. The judge openly admits there's no single clean definition of a land contract under Michigan law, no checklist, no magic words. Instead, courts are forced to examine intent, structure, and substance, payment terms, interest, equity, title obligations. Every detail matters. And here's the problem for the defendants. When a contract lacks those core elements, judges tend to default to what's written on the page. So the question becomes, can intent override a document that repeatedly behaves like a lease?
there isn't something that says you need this for it to be a land contract. That case also speaks to the issue. Historically, you were stuck with the document. This was in 1999, and it's evolved since then. We note that the interpretation of the statute of frauds has evolved somewhat over time, particularly with respect to the question of whether parole evidence could be admitted to fill out the terms for a contract for the sale of land. And then you can find cases that split hairs between what is a contract for the sale of land and what is a land contract. So they speak of thousands of cases, and so this issue, I think, has come up everywhere for a number of years. There are certain things, however, that are assumed to be in a land contract. The contract must contain these essential elements. The contract must be in writing. It must set forth the terms of the agreement with sufficient certainty and definiteness. It's specify the identities of the parties and their mutual assent. It must identify the property which is the subject of the contract. It must identify the price of such property and the consideration. It is essential that an enforceable real estate contract either sets forth the price to be paid by the purchase or furnish a basis from which the price may be ascertained. Defendant argues that there is a way to ascertain what the price is if you amortize the payments. It requires that an adequate description of the land be included in the contract. Finally, it requires the identification of the parties. There's another case that says the amount of time for installments payments must be established, the rate of interest at which the material terms of contract are in the sale of land contract. If you did extrapolate the payments as plaintiff or defendant contends, it went from 1,140 to 1,380. I calculated the actual purchase price would have been in the neighborhood of $133, $133.60, 133,060. And
$133,000.
$133,060. And that may not be penny on, somewhere in that vicinity. There's also a case, this is just an aside that I reviewed as a part of this, which was a very important case at the time. It came out in 1979. I was a law student in 1979 in my second year in law school. And for reasons that seemed important at the time, I was on the law review at Wayne State University. But it turned out haven't been very important since, but the first year law review students, second year law students were often given an assignment to write a case note, which is to write an article about a specific case, in this case regarding Michigan law. And the case I got for my case note was Kruskin versus Fisher, the quintessential question about the election of remedies in a land contract case, whether they have to take the property or they can seek damages. That doesn't solve the question. Now, as Mr. Davidson argues, from the face of the document, without parole evidence, I'll get to it. And his contention has always been, from the first moment they filed it, that this was a lease. Now, there was something entitled Personal Home Property Lease / Purchase Agreement, March 21 through March 28. That is Exhibit B, and that's the exhibit where that's the contract that's at issue here. There was a previous document from 2019 as Exhibit A, which is entitled Personal Home and Property Rental Agreement, 2019 to 2020. Still looking for what I'm looking for here. Defendant argues that if we use the parole evidence and look at all the ancillary information, that we can discern that the tension was for a land contract. Mr. Davidson argues in his brief on page 4 that the contract does not contain a price. It does not bear interest. It does not specify a principal amount that will constitute equity. It does not allow for the purchaser to pay off or any right other than for timely payments of rent. There was no warranty of title or promise of title insurance. The payer did not pay the property taxes. They also didn't use the homestead tax exemption, and the contract was not recorded. Counsel for the defendants argues that their intentions were to have a land contract where there would be some sort of balloon payment at the conclusion in that price neighborhood that I set forth earlier, $133,060. So when we go back to look at the actual document, which is what's at issue, is this a land contract or is this a lease? It's Exhibit B of defendant's brief. Mr. Davidson's might be Exhibit A, but I'll call it Exhibit B. It's got a better sticker on it. It says personal home property lease. So it's entitled on its face to be a lease. That doesn't make it one, but that's what it says. At one point, or in paragraph 2, the document contains a late fee of $125 per month. That's probably more than I would allow in an actual lease, but that's not a land contract provision. That's a lease provision. And most damning of all, the very last paragraph of the document, Mark David Hart Jr. and Johanna Grace agrees to immediate eviction for non-payment of the lease purchase agreement past 30 days. That's not a land contract provision. That's a lease provision.
This is the moment everything collapses for the defense. The judge zeroes in on one devastating clause: immediate eviction for non-payment. That single sentence wipes out the land contract argument. Why? Because land contracts don't work that way. Buyers don't lose property rights after 30 days like tenants do. When the judge calls this the most damning provision, the outcome becomes clear. No redemption period, no equity protection, just a lease and a ticking eviction clock.
It directly contradicts the relief requested under a land contract. I'm not sure that that would withstand the Landlord-Tenant Relationship Act, but Mark Hart and Johanna Green agreed to immediate eviction for non-payment of lease purchase agreement past 30 days. So they agreed to that, which is not the protection offered by a land contract. It's protection offered by a lease. So I was not able to find a smoking gun case that says this is a land contract and this is a lease. But after reviewing the case law, the statutes, the court rule, everything I could find in the district court landlord-tenant bench book and in Ickles pleadings, I believe this document is a lease, not a land contract. Mr. Green and Ms. Hart, you have 10 days to vacate or you're subject to being evicted. 10 days from today is January the 19th. You also have 10 days to appeal this, and you can discuss that with your lawyer.
Your Honor,
Yes.
if I can interject, if there is any way that we can have 30 days for our client to be able to leave, they have in the escrow account have paid through the end of January, which will be released to the other side. Moreover, they've lived there for 7 years and have 2 little kids, and they need more than 10 days to be able to
All right.
vacate the property.
Mr. Davidson and Mr. Williams and Ms. Williams, you're willing to allow 30 days from today,
We're
which
going to talk about it for just a second.
yeah,
Please,
certainly.
Thanks. If you'll give us just a second.
This is kind of how my day has gone. I've spent a lot of time here on the bench looking at the
Yeah.
back wall while people were talking with their clients. You did note their escrow is paid most recent payment on January 6th. Mr. Davidson, I did speak off the record while you were out in the hall. I did confirm Ms. Patel's contention that the lease payment has been received January 6th. 1,140 is being held in escrow by the court. We have November, December, and January's rent in escrow.
Well, what I was going to ask you is, what is the court's general procedure for releasing the rent? Because our position would be they owed rent for the 5 months prior to the time it got filed. Well, let me get back to well, go ahead. Because I would have thought that within 52 days, we file a claim for the rent. and more rent and, whatever the money damages like would be handy. And the court would say, well, that's fine. And I'm going to give you the money that I'm holding for you because you're
Well,
entitled to
my
it.
inclination at this point is to release the escrow to the plaintiff. They've been in possession of the premises November, December, and January. If there's other unpaid rent in the past, that could be subject to further.
So that's why I was asking what your
Yes.
position on Resco, right?
Yes.
On
Now,
escrow is.
if you go into December, February, there'll be an issue of February's rent also being due. I'm not gonna order that as part of the escrow. I'm simply gonna release the escrow to the plaintiffs. And if they agree till 30 days from today, which would be February the 9th, that would give the defendant sufficient time to vacate.
I'm trying to think how to say this in a way that's polite. For what the plaintiffs have had to go through and for what it's cost them, they're not inclined to give an additional 30 days at this time.
Well, is there a middle ground? Are you willing to go till the end of January 31st?
But yeah, it's kind of the same. I mean, I kind of asked them and
All right, well,
whether it's just because they're hurt, they're frustrated, they're upset, but that ship has sailed. I guess that's just kind of the, to ask for that at this point is unreasonable.
Well, the defendant stated it. There's not much of a familial relationship here. They don't consider one. So I guess they get 10 days to move out. Eviction is really ugly. It involves the sheriff coming and putting all your stuff out in the street. It's equally as ugly for the landlord. It's way, way easier to allow the tenant to move out themselves and have the sheriff come out with a crew and do it. But because of hard feelings, the plaintiffs aren't willing to do that. This also probably would guarantee that there's going to be an appeal filed, which will stay the eviction. And then you could fight about this for 5 more months. But if you're not even willing to concede till January 31st, I'll give you the relief that the law says, which is 10 days.
It still gives them the opportunity to give them more time.
That's true.
So in other words,
Let
the
me-
fact that it has to be out by 10 days doesn't mean that they have to,
Yes.
they can still take this all into consideration.
Mr. Davidson raises a good point that I often, in fact, almost always raise. The law says you have 56 days from today to ask for the writ of eviction. So you don't have to evict them on January 19th. You have 56 days from today, which would be sometime in early March. And then you have 56 more days to serve the writ. You have 56 days to get it and 56 more to serve it. So there is discretion in the landlord to allow the defendant time to move out. And I often say if they've got a moving van backed up to the house, there's no sense having Sergeant Morse and the crew pursue an eviction. They also leave the place in a mess. So you have the discretion to give them more time. You do not have to evict them on January 19th. You have 46 more days from that to ask for the writ and 56 days more to serve it.
Your Honor, the other issue too is the promise to move out in 30 days doesn't mean that happens. And we
Correct.
see this over and over and over. And there's also an issue perhaps of the plaintiffs not trusting that promise.
All right. Well, you'll have discretion after 10 days from now. Now, as a practical matter, I won't be back here until January 21st. So the earliest this writ could get signed would be January 21st. But as I said, if there's progress being made toward vacating, you don't have to ask for the writ. And Mr. Davidson's right. There have been many occasions where they grant 30 days and they still don't move, and there's still a writ of eviction at the end of 30 days. This puts the discretion in the plaintiff. So Ms. Patel, you can discuss how your clients wish to proceed. Mr. Green and or Ms. Green and Mr. Hart, the feelings are so strained here that makes it difficult, but you have to speak to each other. If you're gonna try to get you haven't even taken your Christmas tree down yet, you'd be moving from ground zero. And that's very difficult to do in 10 days. So you're gonna need to talk to each other. I'll just leave it at that. But I'm granting the relief that the statute says the plaintiff is entitled to. Date for the writ is January 19th. The date for the appeal is January 19th. There is no money judgment at this time. I'm not ordering that you pay any money. I'm also ordering the escrow funds may be released to the plaintiff. As a general rule, in a termination of tenancy case, the landlord is not entitled to receive rent during the pendency of the case. There's a case called Park Forest, which prohibits the landlord from accepting rent because it turns it in from a termination of tenancy to a non-payment of rent case. This was under order of the court pursuant to escrow because I thought this would take a while, and it has. So the escrow funds may be released to the plaintiff. All right, which is an issue because they paid rent through January. The writ of eviction is through the 19th. So if there is a later claim for damages, they may get some credit if they vacate before the end of the month. All right, everybody's got my order. I've done a judgment. Ms. Patel, thank you. I've enjoyed dealing with you, and you did an excellent job in your pleadings. Mr. Green, or Miss Hart and Mr. Green, you're going to need to talk to the Williamses, and you're going to need to talk to them. But you're going to get your property back relatively soon. All right, that completes the hearing in this matter.
In the end, the court ruled strictly by the law and the language of the contract. Despite years of occupancy and emotional appeals, the document functioned as a lease, not a land contract. That meant no ownership rights, no redemption window, and a lawful eviction order. This case is a powerful reminder: what's written matters more than what's intended. If you found this ruling as intense and eye-opening as we did, hit like, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.
Everybody, hope for the best.
Thank you, Your Honor. Thank you, counsel.